like to introduce Mark Young. He's very active with us, and he's been here for the last 2 weeks, and he's been here for many other activities. If you get a chance to check out his website, it's at youtube.com/MarkYoung12. That's youtube.com/MarkYoung12. You'll get to hear the voices of those alienated and afflicted by our government. If you're a grandfather, a grandmother, aunt, or uncle, there's rights that are being taken away from you today that shouldn't be. You have a right to seek change. We have the First Amendment. So use it. With that, here's Mark Young.
I'd like to talk a little bit today about why we're here, and that's a violation of the founding documents of our country, the Declaration of Independence and the United States Constitution. A lot of people don't realize that we really don't need new laws, except maybe to get rid of the state laws that pretend to give judges discretion to deny a fit parent their right to be a parent. There's plenty of federal case law saying that you have a fundamental right to be a parent. A fundamental right is one that existed even before the U.S. Constitution, one that you were born with. We're all born with fundamental rights. The right to life, liberty, pursuit of happiness. And the right to be a parent is one of those rights. There are plenty of federal case decisions on that topic, and I have some of those with me today. I'd just like to go through those a little bit here. And these can be found on my website, exiledfathers.org. These are excerpts of case law from state, appellate, and federal district courts and up to the U.S. Supreme Court, all of which affirm, from one perspective or another, the absolute constitutional right of parents to actually be parents to their children. The rights of parents to the care, custody, and nurture of their children is of such character that it cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all our civil and political institutions, and such right is a fundamental right protected by this amendment, that is the first, and Amendments 5, 9, and 14. That's from Doe v. Irwin. It's a 1985 Michigan case. Another case, the several states have no greater power to restrain individual freedoms protected by the First Amendment than does the Congress of the United States. That's Wallace v. Jaffrey, 1985 Supreme Court case. Loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Though First Amendment rights are not absolute, they may be curtailed only by interests of vital importance, the burden of proving which rests on their government. That's from Elrod v. Burns, 1976. Some may wonder why the First Amendment comes into family law. But part of the First Amendment is the right to freedom of speech. And that would entail the right to raise your children according to your belief systems. Well, if the state is going to deny and take your kids away from you, then you lose your right, your First Amendment right to raise them according to your belief system. And that's a case called Yick Wo v. Hopkins, a 1886 U.S. Supreme Court case. Even when blood relationships are strained, parents retain vital interest in preventing irretrievable destruction of their family life. If anything, persons faced with forced dissolution of their parental rights have more critical need for procedural protections than do those resisting state intervention into ongoing family affairs. That's from Santosky v. Kramer, 1982 U.S. Supreme Court case. Parents have a fundamental, constitutionally protected interest in continuity of legal bond with their children. That's the case of Matter of Delaney, an Oklahoma case, 617 Pacific 2nd, 886, 1980. The liberty interest of the family encompasses an interest in retaining custody of one's children, and thus a state may not interfere with a parent's custodial rights absent due process protections. That's Langton v. Maloney, 527 Federal Supplement 538, a 1981 case. A parent's right to custody of a child is a right encompassed within protection of this amendment, which may not be interfered with under guise of protecting public interest by legislative action, which is arbitrary or without reasonable relation to some purpose within competency of state to effect. That's Reginald v. Baby Fold, Inc., 369 Northeast 2nd, 858, an Illinois case. And it went to the Supreme Court in 1977, 435 U.S. 963, Illinois. Now, that may be Illinois case. No, it went to the Supreme Court. Parents' interest in custody of her children is a liberty interest. Let me repeat that. A parent's interest in custody of her children is a liberty interest which has received considerable constitutional protection. A parent who is deprived of custody of his or her child, even though temporarily, suffers thereby grievous loss, and such loss deserves extensive due process protection. That's from In the Interest of Cooper, 1980 Kansas case. The Due Process Clause of the 14th Amendment requires that severance in the parent-child relationship caused by the state occur only with rigorous protections for individual liberty interests at stake. That's Bell v. City of Milwaukee, 746 Federal 2nd, 1205, U.S. Court of Appeals, 7th Circuit, Wisconsin, 1984.